Please subscribe, like and share this video. Thank you for your support.
2 U.S. Code Chapter 24, Congressional Accountability. 2 U.S. Code Subchapter 3, Office of Congressional Workplace Rights. 2 U.S. Code Paragraph 1381, Establishment of Office of Congressional Workplace Rights. A establishment there is established, as an independent office within the legislative branch of the federal government, the Office of Congressional Workplace Rights. B. Board of Directors. The office shall have a board of directors. The board shall consist of 5 individuals appointed jointly by the Speaker of the House of Representatives, the Majority Leader of the Senate, and the Minority Leaders of the House of Representatives and the Senate, who are authorized to take such steps as they consider appropriate to ensure the timely appointment of the members of the board consistent with the requirements of this section. Appointments of the first 5 members of the board shall be completed not later than 90 days after January 23, 1995. C. Chair. The chair shall be appointed from members of the board jointly by the Speaker of the House of Representatives, the Majority Leader of the Senate, and the Minority Leaders of the House of Representatives and the Senate. D. Board of Directors. Qualifications. 1. Specific qualifications. Selection and appointment of members of the board shall be without regard to political affiliation and solely on the basis of fitness to perform the duties of the office. Members of the board shall have training or experience in the application of the rights, protections, and remedies under one or more of the laws made applicable under Section 1302 of this title. 2. Disqualifications for appointments. A. Lobbying. No individual who engages in, or is otherwise employed in, lobbying of the Congress and who is required under the Federal Regulation of Lobbying Act 1 to register with the Clerk of the House of Representatives or the Secretary of the Senate shall be eligible for appointment to, or service on, the board. B. Incompatible office. No member of the board appointed under subsection B may hold or may have held the position of member of the House of Representatives or Senator, may hold the position of officer or employee of the House of Representatives, Senate, or instrumentality or other entity of the legislative branch, other than the office, or may have held such a position, other than the position of an officer or employee of the General Accounting Office Personnel Appeals Board, 2. An officer or employee of the Office of Fair Employment Practices of the House of Representatives, or officer or employee of the Office of Senate Fair Employment Practices within 4 years of the date of appointment. 3. Vacancies. A vacancy on the board shall be filled in the manner in which the original appointment was made. E. Term of office. 1. In general except as provided in paragraph 2, membership on the board shall be for 5 years. A member of the board may be reappointed, but no individual may serve as a member for more than 2 terms. 2. First appointments of the members first appointed to the board. A. 1 shall have a term of office of 3 years, B. 2 shall have a term of office of 4 years, and C. 2 shall have a term of office of 5 years, one of whom shall be the chair, as designated at the time of appointment by the person specified in subsection B. 3. Permitting service until appointment of successor. A member of the board may serve after the expiration of that member's term until a successor has taken office. F. Removal. 1. Authority. Any member of the board may be removed from office by a majority decision of the appointing authorities described in subsection B, but only for A. Disability that substantially prevents the member from carrying out the duties of the member, B. Incompetence, C. Neglect of duty, D. Malfeasance, including a felony or conduct involving moral turpitude, or E. Holding an office or employment or engaging in an activity that disqualifies the individual from service as a member of the board under subsection D. 2. 2. Statement of reasons for removal and removing a member of the board. The Speaker of the House of Representatives and the President pro tempore of the Senate shall state in writing to the member of the board being removed his specific reasons for the removal. G. Compensation. 1. Per diem. A. Rate of compensation for each day. Each member of the board shall be compensated for each day, including travel time, during which such member is engaged in the performance of the duties of the board, at a rate equal to the daily equivalent of the lesser of I. The highest annual rate of compensation of any officer of the Senate, or 2. The highest annual rate of compensation of any officer of the House of Representatives. B. Authority to prorate. The rate of pay of a member may be prorated based on the portion of the day during which the member is engaged in the performance of board duties. 2. Travel expenses. Each member of the board shall receive travel expenses, including per diem in lieu of subsistence, at rates authorized for employees of agencies under Subchapter I of Chapter 57 of Title V, for each day the member is engaged in the performance of duties away from the home or regular place of business of the member. H. Duties. The office shall 1. Carry out a program of education for members of Congress and other employing authorities of the legislative branch of the federal government respecting the laws made applicable to them, and a program to inform individuals of their rights under laws applicable to the legislative branch of the federal government. 2. In carrying out the program under paragraph 1, distribute the telephone number and address of the office, procedures for action under Subchapter 4, and any other information appropriate for distribution. Distribute such information to employing offices in a manner suitable for posting. Provide such information to new employees of employing offices, distribute such information to covered employees by the end of each fiscal year, and conduct seminars and other activities designed to educate employing offices and covered employees. And 3. Compile and publish statistics on the use of the office by covered employees, including the number and type of contacts made with the office, on the reason for such contacts, on the number of covered employees who initiated proceedings with the office under this chapter and the result of such proceedings, and on the number of covered employees who filed a claim, the basis for the claim, and the action taken on the claim. I. Congressional oversight. The board and the office shall be subject to oversight, except with respect to the disposition of individual cases, by the Committee on Rules and Administration and the Committee on Governmental Affairs 2 of the Senate and the Committee on House Oversight 2 of the House of Representatives. J. Opening of office. The office shall be open for business, including receipt of requests for counseling under Section 1402 of this title, not later than 1 year after January 23, 1995. K. Financial disclosure reports. Members of the board and officers and employees of the office shall file the financial disclosure reports required under Subchapter I of Chapter 131 of Title V with the Clerk of the House of Representatives. L. Annual reports on awards and settlements. 1. In general, subject to the rules issued by the applicable committee pursuant to paragraph 2a requirement, the office shall prepare and submit to Congress, and publish on the public website of the office, an annual report regarding payments from the account described in Section 1415a of this title that were the result of claims alleging a violation of Part A of Subchapter 2, referred to in this subsection as covered payments. B. Reporting. The reporting required under this paragraph shall, I. For a covered payment, or the reimbursable portion of a covered payment, described in paragraph 2, conform to the requirements of the rules issued by the applicable committee under such paragraph, and 2. For a covered payment, or the portion of a covered payment, not described in paragraph 2, I. Include the amount of the covered payment or portion of the covered payment and information on the employing office involved, and 2. Identify each provision of Part A of Subchapter 2 that was the subject of a claim resulting in the covered payment or portion of the covered payment. C. Reporting periods and dates. The reporting required under this paragraph, I. For 2019, shall be submitted by the 60th day after the date on which the committees described in paragraph 2 issue the rules described in paragraph 2 and shall reflect covered payments made in calendar year 2019, and 2. For 2020 and each subsequent calendar year, shall be submitted by January 31st of that year and shall reflect covered payments made in the previous calendar year. 2. Rules regarding reporting of covered payments for employing offices of the House and employing offices of the Senate. A. In general, not later than 180 days after December 21, 2018, the Committee on House Administration of the House of Representatives and the Committee on Rules and Administration of the Senate shall each issue rules establishing the content, format, and other requirements for the reporting required under paragraph 1b. I. With respect to I. Any covered payment made for claims involving an employing office described in any of subparagraphs A through C of Section 1301A9 of this title of the House of Representatives or of the Senate, respectively, and 2. The reimbursable portion of any such covered payment for which there is a finding requiring reimbursement under Section 1415d1b of this title from a member of the House of Representatives, including a delegate or resident commissioner to the Congress or a senator, respectively. B. Applicability. The rules issued under subparagraph A. I. by the Committee on House Administration of the House of Representatives shall apply to covered payments made for claims involving employing offices described in subparagraph A. I. of the House, and 2. by the Committee on Rules and Administration of the Senate shall apply to covered payments made for claims involving employing offices described in subparagraph A. I. of the Senate. 3. Protection of identity of individuals receiving awards and settlements. In preparing, submitting, and publishing the reports required under paragraph 1, the office shall ensure that the identity or position of any claimant is not disclosed. 4. Authority to protect the identity of a claimant. A. In general, in carrying out paragraph 3, the executive director, in consultation with the board, may make an appropriate redaction to the data included in the report described in paragraph 1 if the executive director, in consultation with the board, determines that including the data considered for redaction may lead to the identity or position of a claimant unintentionally being disclosed. The report shall note each redaction and include a statement that the redaction was made solely for the purpose of avoiding such an unintentional disclosure of the identity or position of a claimant. B. Record keeping. The executive director shall retain a copy of the report described in paragraph 1, without redactions. 5. Definition. In this subsection, the term claimant means an individual who received an award or settlement, or who made an allegation of a violation against an employing office, under Part A of Subchapter 2. M. Record retention. The office shall establish and maintain a program for the permanent retention of its records, including the records of preliminary reviews, mediations, hearings, and other proceedings conducted under Subchapter 4.